way it deals with federalism, the way it deals with the state and the union territory, the way it deals with the way it seeks to wipe out the entire history of Kashmir. I think it needs to be all this needs to be discussed at length, and that's why we are having this meeting today. We have three speakers. We will start with Sanjay Parikh. Sanjay Parikh is a member of the PUCL, was for a long time the National Vice President, stepped down in order to focus more on issues concerning PUCL and other public interest issues in court to argue those matters. And he has been the one who argued on the PUCL, had also filed a petition in the Supreme Court challenging the abrogation of 370. And he was the senior advocate who argued the matter on behalf of PUCL in the Supreme Court. So may I first request Sanjay, okay, to explain what the complexities of the judgment in about 20 minutes. Sanjay, please go ahead.
Yeah, thank you. Thank you, Mihir. Though the issue is a little complicated, but I'll try to put it as briefly as possible so that we can have more time for discussion. Few dates are, I'm not going into the background, the historical background, because I think all of us know about the background in which all the proclamations were issued by the Maharaja. What is important for the discussion is certain dates, which you may kindly note, that the accession was signed by, initially Maharaja Hari Singh was not agreeing, but then ultimately, due to the tribal invasion which had taken place, that the accession was signed on 26th of October 1947. Now the instrument of accession provided that as far as the Dominion legislature is concerned, can legislate with regard to three issues basically: the defense, external affairs, communication, and it also mentions actually the ancillary matters. So ancillary matters may include the other matters which are connected with defense, external affairs, and communication. Now, after this instrument accession, and that one argument which we had advanced was till the Constitution of Jammu and Kashmir was enacted, the instrument accession was really governing the field. And that is what the judgment in Pirimnath call, the Constitution Bench said. Now, after the signing of instrument accession, there was a proclamation by Maharaja on 5th of March 1948. In the proclamation, he talked about setting up of the democratic form of government in Jammu and Kashmir. And also, that was creation by Maharaja himself, the J&K Constituent Act of 1939, Constitution Act of 1939. It was also decided, because that time the Constituent Assembly was already convened on 19th of December 1946, which was functioning. So they decided that 4 representatives will represent the issue of Jammu and Kashmir before the Constituent Assembly. So there was a due participation of the members of the Kashmir Assembly, the people of Kashmir, before the Constituent Assembly. Now the discussion took place and 370 was adopted on 17th of October 1949. And then our constitution came into force on 26th of January 1950. That's how 370 came. Now, after this, there were certain constitution orders which are issued by the president. The first order was on 26th of January 1950. Now, that particular first order is important because thereafter, the Constituent Assembly of J&K was convened. So it was convened on 5/11/1951, and it was the Constitution of J&K was adopted on 17/11/1956, and finally it was dissolved on 26th of January 1957. So within this, these facts show how 370 was ultimately framed. So 370, framing of 370, there was an instrument accession. Then the debates which had taken place in the Constituent Assembly, where the representatives of J&K were present. And the idea was that whatever the provisions of the Constitution which should apply to Jammu and Kashmir will ultimately be okayed by the Constituent Assembly of Jammu and Kashmir. That was the basis of it. So 370, if you look at, 370 is actually divided into three parts. The first part, if you look at, it talks about the consultation. So certain matters which I mentioned, defense, commerce, external affairs, ancillary matters, etc., they can be taken where the parliament will have power to legislate. So therefore, the parliament legislated with regard to those four topics. So it only talked about that what is necessary is the consultation. Now, with regard to other matters, if you look at the other provision was that there should be concurrence. And concurrence has been defined as concurrence with regard to other subjects other than whatever were mentioned in the instrument accession, that it will require a recommendation of the Constituent Assembly or approval from the Constituent Assembly. Now, there were about 6 presidential orders which are issued. Now, those 6 presidential orders, all those presidential orders ultimately were approved by the Constituent Assembly. The Constituent Assembly, as I mentioned, convened in 1951, and when it was adopted in 1956 and ultimately dissolved in 1957. Out of these presidential orders, there is a presidential order where they wanted to change in the explanation Maharaja of Jammu and Kashmir by Sadr-e Riyasat. So when that was, an amendment was to be made in 370, they said a concurrence from the prior concurrence from the Constituent Assembly of Jammu and Kashmir is required. So that amendment was made only after the Constituent Assembly, which is provided in 373, agreed that this recommendation before the presidential order is issued, because it says very clearly that recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before President issues any notification. So before any notification is issued, amending 370 I'm talking about, then it is necessary that there should be a recommendation of the Constituent Assembly before the presidential order is issued. So these presidential orders provided specifically when they wanted to amend the provision of 370, the prior recommendation of the Constituent Assembly of Jammu and Kashmir was taken. Then we have Presidential Order of 1954, wherein they wanted to apply certain provisions of the Indian Constitution, Jammu and Kashmir, to be included in the Constitution of Jammu and Kashmir. Now, those provisions were also put before the Constituent Assembly of Jammu and Kashmir, and they were approved. That's how they were incorporated in the Constitution of Jammu and Kashmir. Now, the petition which we had filed and the point which we had taken was that the structure of 370 was temporary in nature. The idea was that whatever is provided in the instrument accession, those 3 subjects, certainly the parliament will have power to legislate. But with regard to the other subjects, the concurrence is required, and concurrence by the people of Jammu and Kashmir. That is to say, the Constituent Assembly which was convened, the idea was ultimately that it should be approved by the people of Jammu and Kashmir in the form of the Constituent Assembly. So the presidential orders which are issued before the Constituent Assembly of Jammu and Kashmir was dissolved, they became an integral part of the Constitution of India. So the idea was that ultimately there should be a link between the Constitution of India and the Constitution of Jammu and Kashmir. And this link was provided by 370. The argument was that once the Constitution of Jammu and Kashmir was framed and it was adopted, thereafter it was not permissible to amend and to incorporate any other thing in the Constitution of Jammu and Kashmir. Nevertheless, there are several presidential orders which have been issued even after 1957, making changes in the Constitution of Jammu and Kashmir or applying certain provisions of Indian Constitution in Jammu and Kashmir. Nurani has taken a point, and which we also took in our petition, that after 57, it was not permissible to make any change or apply any provision of the Constitution to Jammu and Kashmir. But these presidential orders were issued. And one question was that how these presidential orders were issued and then applied, if our argument is correct. The answer which we had given was that 1954 presidential order was with the concurrence of the Constituent Assembly of Jammu and Kashmir, and all these presidential orders which are issued were virtually clarifications and amendments of 1954. There was no presidential order which was issued subsequently, that is to say after 1954 presidential order. The two presidential orders which have been issued, which are challenged, are the only presidential orders which have been issued independently by abolishing the 1954 presidential order, which I will come to it later on. Now, our contention, this particular contention has not been accepted. We have the statements of Gopal Swami Iyengar. I don't want to read it, but very clearly he said that the idea is that whatever has been said in the instrument accession, certainly Parliament will enact, but the other things should be sanctified ultimately by the Constituent Assembly of Jammu and Kashmir, and those laws will be applicable as far as the Jammu and Kashmir is concerned. Same thing was said by Sheikh Abdullah when the Constituent Assembly of Jammu and Kashmir met, and they said this is the structure which has been adopted and debated in the Constituent Assembly framing the Constitution of India, and we agree with that. And the agreement was that the sovereign power of the Constituent Assembly should be accepted. That is to say that the Constituent Assembly of Jammu and Kashmir will have final say with regard to all the subjects in the Constitution which are not mentioned in the instrument accession, where Parliament will have the right to frame the laws. Premnath Call is one judgment, and probably I must mention that initially when our point was argued, we said in view of Premnath Call, which prevails, therefore it should be answered, the 370 challenge, in view of the judgment given by in Premnath Call. Premnath Call also says the same thing. It says that 370, though it's a temporary provision, but this is a link which was provided or conduit which was provided, that ultimately through our Constitution, how the Constitution of Jammu and Kashmir will be framed. And the concurrence or the approval of the Constituent Assembly of Jammu and Kashmir is necessary. Now that particular finding has been given, and according to what we understand and which we argued before the court was that once a Premnath Call, this particular finding has been given, then 370 has to be construed in a manner which is consistent with what Constituent Assembly debates show, what was debated in the Constituent Assembly of Jammu and Kashmir, and what was said in the Constitutional Judgment in Premnath Call. Now, if you look at the findings which have been given by the Supreme Court says that 373, merely because the Constituent Assembly came to an end, did not cease to exist, and the president can continue to issue the proclamations or directions under 370, Article 370. Now, it says that this was only a transitional power as far as the Constituent Assembly is concerned. And once it was dissolved, then the powers which are vested with the president under 373 will not be affected. Now, this is very strange because if you look at 373, it clearly says that the powers of the president to issue any notification will be subject to this, provided that the recommendation of Constituent Assembly of the state referred to in clause 2 shall be necessary before the president issues such a notification. So it is mentioned, it is necessary, mandatory, that the president will issue any kind of a notification only after getting recommendation of the Constituent Assembly. As I said earlier, when they wanted to change Maharaja into Sadr-e Riyasat, then it was done only after the recommendations of the Constituent Assembly of Jammu and Kashmir were obtained. So the construction which has been placed on 370, and it is on this basis ultimately the entire those CO 272 and 273 have been said to be constitutionally permissible, because what has been said is the president has power to issue and the Constituent Assembly will not affect because it's a temporary provision. But there is a contradiction, because as far as if I just mention it seriatim, then it is like this, that initially there was under section 92 of the Jammu and Kashmir, there was governor's order by which the proclamation was issued, which was with prior concurrence of the president under section 92. Now I must mention that section 92 came into was adopted in the Kashmir Constitution because they felt that as far as power under Article 356 is concerned, where the president has power, in Jammu and Kashmir, if there is a breakdown of constitutional machinery, then under section 92, the governor should take care of it with the prior concurrence of the president, and that will be operative for a period of 6 months. In case the state assembly is dissolved, then what was provided and what was debated in the Jammu and Kashmir Constituent Assembly was that there should be election. So if section 92 powers were applied by the governor, a proclamation was issued. Subsequently, the state assembly was also dissolved on 21st of November 2018. But the only option under the Constitution of Jammu and Kashmir was to hold elections. Now, once the state assembly was dissolved and the proclamation was issued, then 356 actually did not come into picture at all. It should not have been invoked, because the idea was, if you look at the presidential order, they said 356 and 357 will not apply. In the subsequent amendments, 356 was applied, 357 was not mentioned, but that's how they brought in 356 into it. But the question is that once a proclamation has been issued by the governor and the assembly has been dissolved, then how there can be a presidential proclamation and which says on receipt of report from the governor that this presidential proclamation has been issued, taking away the powers of the governor which were being exercised under section 92. Now, the argument was that this presidential proclamation which has been issued on 19/12/2018 is something which is malified in nature and fraud on the constitution and in violation of several directions and observations which have been made in SR Bombay's case. Now, this is one part. Now, thereafter, what happens is, after the presidential proclamation is issued under 356, then comes the CO 272. Now, CO 272, I was going through it. It is very important because 272 supersedes actually 1954 presidential order. And it applies all the provisions of the constitution because according to 370, it should have been okayed by or approved by the Constituent Assembly of Jammu and Kashmir. And that's how it was operating. But by virtue of this presidential, CO which was issued, a presidential order, the entire provisions of the Constitution were made applicable by superseding the presidential order of 1954. Not only this, the provision of 367 by which you bring in the, how to interpret the Constitution, they said in 373, where the Constituent Assembly of Jammu and Kashmir has been mentioned, it will be read as Legislative Assembly of the state. So the entire 370 was amended by using Article 367. Now, the majority judgment has said that this CO 272, which has been issued, presidential order, amending 370 of the Constitution, is not permissible. You cannot do it because 373 alone gives the power to either abrogate or amend or modify Article 370 of the Constitution. So therefore, the finding is that this is something which is an unconstitutional act. So if this is an unconstitutional act, to say that in place of Constituent Assembly of Jammu and Kashmir, you could not have brought in the Legislative Assembly of the state, then the question is that if this particular thing goes, then how the subsequent one can come? Because what happens is they bring in the Constituent Assembly of Jammu and Kashmir, they bring in the State Assembly as such. And because the State Assembly is not there, they bring in Parliament in the subsequent one. And that comes on the next state. That is to say, the CO which has been issued 272 on 5th of August 2019, whereby they bring in the Legislative Assembly of the state. Because the Legislative Assembly of the state was not there, they say on the recommendation of the Parliament, because somebody has to give the recommendation. So instead of recommendation of the Constituent Assembly of Jammu and Kashmir, they bring in the Parliament, and by bringing the Parliament, they say the 370 has been amended and they apply all the provisions of the Constitution to Jammu and Kashmir. So the contradiction is that once you say that by virtue of 367 you could not have amended, and if you could not amend, then the Constituent Assembly of Jammu and Kashmir remains as such in Article 373 of the Constitution, then the State Assembly powers cannot be taken over by the Parliament, and the subsequent CO could not have been issued, which is 273. So therefore,
Sanjay,
the entire exercise of only
3 more minutes. Yeah, 3 more minutes. Yeah.
The exercise of, if I summarize the entire thing, that 370 has been construed according to the debates, according to the judgment, according to the very language of 370 in an erroneous manner. It could not have been done because there is a relationship which has been established between the Constitution of Jammu and Kashmir and our Constitution. And that was being portrayed through 370, and 370 was a link. That's number one. Number two is that the presidential orders which are issued were within the framework and understanding of what the Indian Constitution and the Constitution of Jammu and Kashmir says. 54 was issued ultimately with the concurrence and approval of the Constituent Assembly of Jammu and Kashmir. all the subsequent COs which have been issued, the governor's power which has been exercised, the presidential proclamation which has been issued, on the face of it shows that there was virtually, if I use the language which is a little harsh, fraud on the constitution, and the findings which have been given are also contradictory in nature. The sovereignty argument, which is the internal sovereignty doesn't remain, Justice Sanjay Kishan Kaul disagrees with it, but that's in that sense a minor point, because our argument was that the sovereignty rests with the people, and sovereignty ultimately is translated in the form of the Constitution of Jammu and Kashmir. Unfortunately, the directions have gone to the extent of saying that after this CO 273 has been issued, then the Constitution of Jammu and Kashmir comes to an end, is inoperative and declared to be redundant. That's what has been said. Now, as far as I just take 1 minute, the federal structure under Article 3 is concerned, that's a very important argument. And the court clearly said that once there is a state, the state cannot be bifurcated into two territories. That was, and then Solicitor General was asked in the court to take instructions. Now the question is, once you find that the exercise of any power under the reorganization has been done in violation of the provision of the Constitution, then you should have decided that question. Now that has been left only on the basis of the statement which was made by the Solicitor General, and at the same time saying, as far as the validity of carving out the Union Territory of Ladakh is concerned, that is all right. That need not be upholding the validity of that action. So there is a contradiction, because if you wanted to decide, then you should have decided the entire exercise of power, whether the reorganization act which has been brought into force is something which is constitutionally permissible. So therefore, it affects in a very serious way the federal structure of our constitution and the federalism principle as such. So these are some of the points. There is some question, then I'll answer.
Thank you, Sanjay, for a very illuminating overview of what the judgment says in the history of how things have happened there. And the important point on which you ended, that the court relies on the Solicitor General's statement that actually the Union Territory will be converted into a state at some stage. That reliance itself is something which is shocking, because ultimately the Solicitor General cannot speak for the Parliament. Parliament is to enact it, and no individual can speak for the Parliament. So, but this has been happening, reliance on Solicitor General statements right from the time the migrant workers case was there during COVID. Our second speaker is going to be Mirza Saaib Beg. We have three speakers today. The second is Mirza Saaib Beg. The third will be the third speaker will be Anuradha Bhasin. Now, Mirza Saaib Beg is a lawyer from Kashmir. He was awarded the Kofi Annan and the Weidenfeld Hoffman Scholarship at the Blavatnik School of Government, University of Oxford, where he studied public policy. He's a gold medalist, graduate from the Nalsar University of Law, and he regularly writes and comments on legal and political issues concerning Kashmir. These are very incisive writings and incisive talks which he gives. He will basically be talking about the state propaganda used to justify the deoperationalization of Article 370, the arguments of terrorism, development, and how 370 was bad for instance, LGBTQ rights, and what is happening right now, delimitation, domicile laws, etc. So this is what he is going to speak about. Mirza, can you take over?
Thank you. Apologies for some technical issue at my end. So in case my voice drops off, I'll have to log out and log back in again. But over the course of the next few minutes, I'll try to give a brief overview of these points. So first of all, to begin with, on something anecdotal, the Indian government's action in Kashmir is not without parallel in the world. And in the first year, in 2019, when it was implemented, and once the haze, once the shock of what had happened to us had started to wear off, I felt that it was quite reminiscent of the Milosevic regime, which in 1989 had unilaterally revoked Kosovo's autonomy and imposed direct rule from Belgrade on Kosovo. But that episode would contain a relevant reminder for posterity, because that story did not end well for Yugoslavia. And while no one can predict precisely how this move will affect one of the most volatile places in South Asia, and in the years to come, what will happen from this. But the one thing that is clear over here is that this action reminds Kashmiris about the nature of Indian rule in Kashmir, that even the pretense of consent is immaterial. And not just today, but throughout Kashmir's 7-decade long political history with the Indian state, there aren't points of time that we can refer to where the Indian state has made decisions about our future that take into consideration our political will. And there is a continuous punctuation of interference in our political history, whether it's the 1953 arrest of the Prime Minister, the 1964 arrest of another Prime Minister, the 1965 changing of the nomenclature, then externment orders against political leaders in Kashmir, the 1976 toppling the government, and again toppling in 84. The state has continuously maintained control by interference in any free and fair politics in Kashmir. And this control has also been maintained, of course, by sheer disinformation and coercion, part of which we'll try to touch upon today. So around 2019, when this decision had been taken, India was already suffering from a shaky economy. There was unemployment and a lot of social unrest. But the ensuing distraction which emerges from these kinds of issues, it suits the hyper-nationalist posturing of the present government. And it also feeds into a system of exploitation that is pervasive in India, where multinational corporations are given a free hand to capture land and resources while holding the population under the bayonet in the name of national interest. And in the case of Kashmir, this national interest is just a brew of a majoritarian agenda and a very risky political adventurism. But specifically, the deoperationalization of Article 370 paved the way for bifurcation and delimitation, both of which have legal and political consequences now. Apart from the resource grab, which is now taking place without the facade of any local leadership, we saw how mining tenders were conducted in Kashmir in an online format when internet was restricted in Kashmir, and almost all those tenders went to people from outside Kashmir. We also heard from the ex-governor Satyapal Malik, who claimed that he was offered a 300 crore bribe for approving a contract to Reliance General Insurance Corporation for a group health insurance scheme for the employees of J&K government. We also saw how the Forest Advisory Committee cleared hundreds of projects immediately while we had no elected government in place, and hundreds of acres of forest land were diverted without the consent of local communities. It bears a reminder over here that we are a very fragile ecological zone. We have glaciers in Kashmir, and we have already seen how unplanned development in many Indian cities have made them some of the most polluted places in the world. And allowing direct access to our forests and natural resources is only going to cause irreversible damage to us. On the point of delimitation, the BJP has been raising this demand for quite a while now, especially since 2008 after the Amarnath land row. And the argument for delimitation is largely that the Kashmir division has a larger portion of electoral seats, and so delimitation is required to appropriately represent the Jammu division of the state. Kashmir had 46 seats and Jammu had about 37 seats in the pre-bifurcation point. And now, after bifurcation, we have two separate union territories, and the Kashmir division and Jammu division are in one union territory. Before the bifurcation, there were about 149,000 voters per constituency in Kashmir and about 145,000 voters per constituency in Jammu, which indicates a roughly fair distribution. But the total population in Kashmir Valley, which accounted for this, was 54%. So 54% of the population of Kashmir Valley was represented by about 53% of the seats. And the Jammu division had 42% of the population, which was represented by about 42.5% of the seats. So the distribution was not an unfair one, and the argument that is being made is misplaced. But it is another reminder, another example of how a political exercise is being adopted, is being abused to control political power through either a gerrymandered style or a malapportioned constituency style that can favor a conducive result for a ruling party. There's also been a lot of propaganda against Article 370 itself, as Mihir had pointed out in the brief opening about terrorism or about national security. Whereas Article 370 never imposed restrictions on the Indian military or intelligence to for counter-terrorism measures. India had always been free to conduct operations in Kashmir, and the state has not been able to discharge any burden as to what was being prevented till now, what stopped any government till now from tackling any issues in Kashmir. That will now not be an issue. The center has always had a free hand in deciding how to tackle any issues from sedition to armed rebellion. So, what was missing in the existing collection of laws of AFSPA, Public Safety Act, all the other laws that were preventing the government till now? The other issue they kept highlighting was, in fact, this was something that Amit Shah had made a reference to in a speech in Parliament as well, about how the NC and PDP, which are the two pro-state, pro-India parties in mainstream political elections in Kashmir, about how they had monopolized power over there. And he made a reference to how ye do parivaron ne monopolize kar rakha hai. So the first issue there is that what is wrong in it if they were legitimately elected? Because if they are legitimately elected, then if they are in power, they are in power. Now, within Kashmir, of course, there is a challenge to the legitimacy of NC and PDP because they are perceived to be participating in rigged elections, or at the very least, they are seen to be participating in elections which are not free and fair. But for the Indian government to call them legitimate when convenient and illegitimate when it's not convenient is just foolhardy, because they are the representatives of a system which is representing the Indian state in Kashmir. In fact, both NC and PDP have worked closely as partners of the BJP in Kashmir. The PDP was part of the most recent coalition government, and Umar Abdullah in 2001, he was the Minister for External Affairs in the NDA government. So when the Indian government chooses to call these political parties as illegitimate, it is effectively calling itself as illegitimate over there. And there's one argument on development which has been used quite extensively, that about how Article 370 was preventing development of Kashmir and preventing investment of Kashmir into Kashmir. But if at all there was a lack of investment in Kashmir, it was because of the political instability. And that itself is not changing by mere deoperationalization of Article 370. And there are plenty of states in India which have no armed struggle, no interference from Pakistan, no United Nations resolutions to deal with, and yet Indians in those states are living in abject poverty. So Article 370 is not a hindrance to any of those states, and nor is it an issue in Kashmir. In fact, Kashmir, despite 72, 75 years of political turmoil now, has around 10% of its population living under the poverty line, whereas the all India average is 22%. And this is even lower than most of the economic powerhouses in India, like Maharashtra or Gujarat. And there's enough data available everywhere now about the human development indicators in Kashmir and how they are far ahead of most of these states. And the issue is that the Indian government has failed to show how Kashmir's previously autonomous status has prevented development. And already there were many Indian industries that were functioning in Kashmir. There are, for example, the Taj luxury hotels, the ITC, they all have businesses in Kashmir. And there are plenty of reports available about Indian states such as Himachal or Uttarakhand, which were subject to all these get-rich-quick schemes and corporate investment routes. And their environments have now been devastated by unplanned construction, unmanageable traffic, which has resulted in the conversion of these idyllic towns into urban slums, where their water bodies have fallen prey to polluted waterways. And as Kashmiris, we have rejected this model of development that is now being forced upon us. Another propaganda that was used quite extensively, especially outside India, was that Article 370 prohibits, it does not allow decriminalization of LGBTQ rights, because in 2018, the Supreme Court of India had decriminalized sexual relations between consenting adults by decriminalizing Section 377 of the Indian Penal Code. And soon after this, there were reports published. In fact, Times of India did a very poorly researched claim that this decriminalization will have to wait in Jammu and Kashmir because Article 370 prevents it. And there was unsubstantiated claims about Kashmir's religious and cultural orthodoxy. But all these kinds of terms have become increasingly interwoven into the language which is used by the Indian state to describe Kashmir, because it gives the state machinery a kind of ostensible superiority to inflict war on the aberrant Kashmiri subject. And this narrative seeks to paint Kashmiris as a people who require subordination for emancipation, and thereby legitimizing a coercive or oppressive instrumentality. But most importantly, the narrative is based on an incorrect position of law, because the Indian constitution envisages that any law declared by the Supreme Court is binding on all courts within the territorial control of India. And that includes courts in Jammu and Kashmir. So this position has already been pronounced by the Jammu Kashmir High Court in the 1995 case of Jankar Singh. And legal experts such as the former Chief Justice Bashir Ahmed Khan and former JK High Court judges Justice Hussain Masoodi, they have already opined that the Indian Supreme Court's judgment on decriminalizing homosexuality is already applicable in Jammu and Kashmir also. In any case, if anyone felt that any law was discriminatory, they are free to file a petition before the court for that. It's very pertinent, it's very ironical that BJP leaders like Subramaniam Swamy, Yogi Adityanath, Rajnath Singh, and Ram Madhav very openly make homophobic remarks. And even the government's the government's stand was abundantly visible at the United Nations when they voted against providing spousal benefits for LGBTQ persons. So I feel that this is not the first time that Article 370 has been watered down or when the rights of Kashmiris have been curtailed. In fact, going way back, the onslaught on Article 370 has been so vicious that as early as 1964 itself, Gulzari Nanda had observed at that time that it has been completely hollowed out. All the contents have been removed. And since then, successive Indian governments have abused Article 370 to hack away further at the rights and freedoms, the autonomy of the people of Jammu and Kashmir. Already, a large part of the Indian constitution has already been extended. 94 of the 97 entries of the union list had already been extended to Jammu and Kashmir. And the governor's power had also been further solidified through other presidential orders in 1970s. They barred the state legislature from amending the powers or the functions of the governor. And successive Indian governments over the last 70 years have manufactured concurrence of the state merely to meet the requirements of the letter of the law. So this constant thread of domination and degradation of the Kashmiris has always been either greeted with compliant silence. And to add insult to injury, there was the media when this incident happened in 2019. This seminal moment of Kashmir's political history was characterized as an onslaught on Kashmir, was being called the beginning of a Naya Kashmir. And quite possibly the Indians who would move to Kashmir under the new rules on domicile law would be the Naya Kashmiris. But on this note of the Naya Kashmiri, I will leave you with some food for thought that after Prime Minister Sheikh Abdullah was arrested in 1953, India's Prime Minister Jawaharlal Nehru spent a decade trying to water down Article 370 and installing a regime in Kashmir that was pliant to the center's requirements. And in the end, Prime Minister Nehru realized that there was no way of forcing integration, and he released Sheikh Abdullah from jail. However, after his death, instead of learning from this misadventure of trying to force a union, successive Indian leaders have spent all these decades gradually integrating Kashmir further, embellishing their actions to forcibly realize a stillborn objective. But meanwhile, given the lack of dignity, the lack of consent, and the lack of any semblance of freedom or democratic credentials, Kashmir's defiant resistance has neither dissipated nor died. And it's only a matter of time before the Naya Kashmiris will come to realize the same thing. Thank you. We'll take some questions after this later.
Thanks, Mirza. I'm sure the participants would have liked to see put a face to your voice, but I believe there is some technical problem which you are facing, and therefore it couldn't be done. I think one of the things which we must notice is that the 370 judgment of the Supreme Court, okay, first of all, comes 5 years after the event has happened. It itself shows the direction in which the Supreme Court was proceeding, namely such a momentous event as abrogation of 370, something which should have been decided immediately. The cases were filed immediately, okay, which something which should have been decided immediately, but it took nearly 5 years for it to be decided, is itself a reflection on where it was going. But not just that. I mean, if you see the earlier decisions on given by the court on the issue of Kashmir, whether it is about habeas corpus petitions which were filed, where nothing whatsoever was done by the court. Habeas corpus requires a person to be brought to the court, a person to be brought to the court and released from any illegal custody. Instead, the court directs people to go and visit that person, and that too with so many restrictions that it becomes difficult to visit that person. You had the other case concerning the internet shutdowns, which were massive. The internet shut down for a long period of time. When the internet was shut down, there was no way. And in the present day and age, it becomes very difficult if internet is shut down. You can't access the job market. You can't access media. You cannot access medical facilities in emergency. You can't give exams at certain places. So internet shutdown was a major issue, where again, our third speaker, Anuradha Bhasin, was a person who went to the Supreme Court and challenged the internet shutdown, on which certain orders were passed by the Supreme Court, which also dealt with 144, the invocation of 144, etc., etc. And after that, the internet shutdowns began to be relaxed. After the judgment, they began to be relaxed a bit. Though I'm not sure whether Anuradha is fully happy with the judgment, but she's going to be our third speaker. She's a senior journalist, and she's editor of Kashmir Times. A very bold person. During her entire career, has been extremely outspoken on issues concerning Kashmir, issues concerning the state repression, etc. So may I invite Anuradha to join and take over, please. Thank you.
Thank you, Mihir. It's difficult speaking after Mirza. He's actually spoken about everything. But thank you for giving me a cue. You know, I would like to start with the internet shutdown, which I feel is an important story now that there is an internet similar. There has been an internet shutdown for a prolonged period, even in Manipur. Yes, the judgment was, I feel, pretty ambiguous, though it did help in providing some immediate relaxation. What the court actually did was, while it is agreeing that it is, right to internet is a fundamental right, it did not say that this needs to be restored immediately. It put the ball in the government's court, and said that the government should review how the internet can be restored. Number two, the court said that, restrictions like internet and Section 144 cannot be imposed for a prolonged period, but the prolonged period has not been defined. We saw it in Kashmir, we are seeing it again in Manipur. And these are some of the challenging problems with the verdict, which leaves that scope of ambiguity for the government to further weaponize it against the people. Having seen the Kashmir experience, I'm not sure how much of that can be replicated elsewhere. But the internet shutdown, which was used to keep the people, keep them out of the cyberspace, it wasn't just the internet, even the phone lines were not working for a long time. The mobile phones were not working for about 2 to 3 months. The landlines were not working for a few months. So to keep people out of communication with each other means to disempower them in many, many ways. It's not only about livelihood. It's not only about your work, your socialization. It is about making them feel isolated and disempowered. And that internet shutdown, which lasted for 6 months, is very effective in introducing new mechanisms of intimidation that have a prolonged effect even after the internet shutdown is over. The internet shutdowns still continue for shorter periods, maybe in shorter areas and pockets, and we don't even get to hear about it. But the new system that has been imposed since 2019, which started during the internet shutdown periods, is of raids, interrogation, crackdowns, detentions, interrogations, and these are repetitively used on a broad set of people, sample of people, and to create an example for the rest, to create a kind of deterrence for the rest, and to effectively silence everybody. This is, I feel, a new way of human rights abuse. The gory form of human rights violations we hear lesser and lesser about. But this human rights violations have assumed an invisible form, and they are exercised through a repetitive cycle of raids, interrogations, detentions, in which people are caught on a daily basis. Their devices are confiscated, and many have complained that the devices are not even returned after, say, if they confiscated 3 devices and one was not returned even after the investigation was over. And so this kind of a cycle, which is invisible and you cannot see, it is much more. It is what do I say? It is tyrannical in a very different way, and it is tyranny in a worse way because it demands absolute obedience, and it demands absolute subjugation and subservience of the people. What has happened within this system of methodically controlling and silencing people, which operates through instilling excessive fear of talking, fear of conversing to another person, fear of even complaining to the government that, the electricity is not working. Even on issues like that, people's homes have been raided. So this has effectively silenced not just, I would say, 3 main the powerful arenas of in any society: the media, the civil society, and the political space. You see, the media is no longer speaking. There are rare occasions when some journalists try to do a critical story, and that would be still be very sketchy. And but investigative journalism has completely disappeared in Kashmir. You look at the local newspapers, they are becoming virtually a mouthpiece of the government. And the media's job is not to highlight the achievements of the government, but to ask questions of the government, to find out what are where the government is going wrong and where the other powerful entities are going wrong, and to become the voice of the marginalized and the oppressed people. Now, what the media is doing is just the opposite and reverse of that. The civil society has completely vanished because there several human rights, not just human rights organizations, even other NGOs are facing a lot of pressure and are being constantly being monitored and surveilled and being interrogated for the kind of funding that they get. Human rights activists have faced much worse flack. We have, especially after Khurram Parvez, who's done immense work on human rights. He's internationally recognized. He was imprisoned and he continues to be in prison. And the third, so this has led to the invisibilization of the media, invisibilization of the civil society, and also the near invisibilization of the political space. Now, the political space, as Mirza said, they were virtually, they were part of the problem, and they were the Indian face within Jammu and Kashmir. They were part of that system, and whatever that the center wanted to do could do it through them. Yet, to some extent, they acted as buffers to protect the interests of the people of Jammu and Kashmir, at least the minimal basic interests. So that buffer seems to have gone. It's not just that the elections are not being held, the entire political space is being squeezed even through these similar ways of, intimidating political workers, even leaders, even top leaders who have been arrested and detained from time to time. There is a disempowerment of, earlier in before 2019, or the governments before the Modi government used to talk about democracy in Jammu and Kashmir in terms of elections. They would see election as the sole indicator of democracy in Jammu and Kashmir, which was flawed. Today, we don't even have those elections. We don't have any tier of, and the government's arguments defy any kind of logic. Earlier they said, okay, in 2018, they said, we'll have panchayat elections and, assembly can wait. Then they had local body elections post 2019. Then they added another layer of, we have to the 3-tier system of elections. They added another layer of district development committees. And without actually clarifying what the powers of each bodies would be. At the moment, I think most of these bodies are now defunct. So any layer of the political process, the political governance, it doesn't exist today. The most important, the assembly, the government does not want to talk about. Now, interestingly, the court verdict on 370, it did mention restoration of statehood and elections, and there's a whole lot of ambiguity about, when the elections can be held. So it isn't even, the court did not deem it important that, this is a state, and a state that has been very, very fragile in many ways, has not had a local government since 2018. It can wait for another year is virtually what the court verdict has said, saying that, elections should be held by September, not even sounding an immediacy about the issue. And about restoration of statehood, it has just taken the, the government's assurance on face value and said it would be restored. So there's a whole lot of ambiguity about it. But what is interesting is that, there were some people who celebrated this. Oh, it's a good verdict because now the people will have elections. And, there were people who were looking at that angle of it. And now that statehood would be restored, so it would be good for people of Jammu and Kashmir. What do they have to complain? And many writers were writing about it. Some media stories tried to anchor their stories to this angle. But it's extremely problematic that nobody would even question that election is a normal democratic process. Why should a court be telling, elections to this region or can be held in another year or so? If it takes the court to say something as ambiguous as that regarding elections in Jammu and Kashmir, it is a reflection of what kind of democracy the place enjoys. The other thing now, why would the BJP government want to keep everybody disempowered? Not just the ordinary people, the people who would speak for them, the media, the civil society, the political faces. It was important for them so that they could easily implement the new laws without anybody having to make any noise about it. And the new laws have been implemented since 2020 at random speed. Even before the Supreme Court had decided on the legitimacy of Article 370. So the new laws that had been introduced after demolition of Article 370 have also changed the entire architecture of, particularly the land-related laws, the revenue-related laws, which would mean that not just that people from outside can come and settle here and buy land and invest in land, invest in businesses, at the risk of marginalizing the local businessmen and the local investors, or take their share of jobs. And these are worries and anxieties of people, not just in Kashmir, but also in Jammu and Ladakh. A, that their jobs will go. B, that people from outside will come and take away their land. The resources will be Jammu and Kashmir is rich in natural resources, and there are fears that when in big mining mafia comes from outside the state, and invests bigger amount of money, uses more machinery, exploits these natural resources without any check, it will have huge ecological consequences, which we're already seeing, say for instance in the sand mining. The sand mining has been done 9 times more by the miners who have come from outside. I mean, and Mirza talked about that, at that time when the sand mining contracts were given, the internet wasn't working, so the locals could not compete with the businessmen from outside. Today, there is no internet problem. I mean, not existing there. But yet, the preference is given to outsiders in terms of investments, in businesses, in hotel industry, in several other areas, wherever the investment. And the land laws have not just, it just doesn't mean that people from outside can come and settle. It also means that several reforms that had taken place in the initial decades after 1947 are now going to be undone, especially everybody talks about the landmark land reforms, which were, of course, the implementation of the land reforms had been poor. Because the local politicians were always part of the problem, because there was political instability in Jammu and Kashmir, and because people who benefited, which included not just Muslims, they also included Hindus, they included a large section of Dalits. They did get possession of their land, but these were illiterate people, and many of them were not even aware of how to get their paperwork done. Second, that there was corruption within the departments. Number three, there was political instability. So a number of reasons that due to which many people who benefited because of the land reforms did not have valid papers. So the new set of laws, under the previous system, the state at least protected the interests of the people, they did not dislodge people who did not have these papers. They protected their land interests. Land was also given on leases to many people. So state in many ways was a protector of people's right to use land. Now all this has gone, and this is being reversed. So many people who benefited because of the land reforms, and this includes a large section of Dalits, they do not have the valid papers to show that to show their ownership. They only have the possession. So many of them are now being evicted from their places. It's an impact on ecology. It's an impact on it takes away the rights of the people to their resources. For instance, electricity. I mean, there's a recent news about the Rattle project going to Rajasthan. Whereas, Kashmir Valley is facing about 14 hours of power cuts on a daily basis in this freezing winter. Similarly, Jammu faces power cuts throughout the year, though, but more power cuts during the summers when it is required. And these are problematic issues. They are by disempowering the people and taking away a huge chunk of the pie of the resources that belong to the people of Jammu and Kashmir. There would be consequences of this. The government keeps talking about 370, there are several myths that they prop up. Mirza talked about some. I'd like to talk about two. That since 370 has gone, there would now be no terrorism. And that terrorism was never linked to 370. Terrorism started in 1990. By then, before that, 370 did exist. And militancy in Kashmir is an offshoot of the political problem. It exists because of over control of the politics and the resources of Jammu and Kashmir actually triggered militancy. And if you can't understand that, I think we would be making wrong decisions. There have been ups and downs in militancy in the last 30 decades. That doesn't mean that it has disappeared. It may be silent. There have been periods when there has been silence. And there is also, if you see, militancy is actually extending from Kashmir Valley to the Pir Panchal belt, to Chenab Valley, more frighteningly in the Pir Panchal belt, which is a border area and which has had a very frightening history in the past. The other myth that the government has, the BJP keeps talking about is that, and it's also popularized by media, that the women did not have equal rights. Now there was an ambiguity regarding women's permanent residence certificates, and this seems to have this did challenge the rights of some women at some point, because executive decision was taken by the revenue minister in 1968, according to which the permanent residence certificates of women were stamped with valid till marriage. Now that, because the state subject laws, which were taken from the old, just copy paste of what the state subject laws of during the Maharaja's time, at which point that understanding of gender equality did not exist. So that ambiguity continued to exist till some women who were impacted by these decisions approached the court. And the court, I think the court verdict finally, after many, many years, came in 2002. And the Jammu High Court decided that women cannot be discriminated against. So that means that the issue was already settled. I remember my state subject certificate, the permanent resident certificate that used to we had during my time, that was stamped with valid till marriage. My daughter, who got I got her permanent resident certificate made about 10 years ago, did not carry that stamp. So the issue was settled. And as far as, I mean, no system anywhere in the world is perfect, and we always try to make systems better according to our newer, evolution of new ideas and our understandings about the world and about equality. And 370 was never a hindrance. These things could have been any kind of a problem, could have been redressed through newer legislations that the state could have come up with at any point in time. But these myths are very important for the BJP to perpetuate, so that they can make it look more legitimate what they have done. And what Kashmir, the first in 2014, when they came to power, they were trying to entrench themselves. So and more subtly, they were trying to bring down the democratic structure of democratic secular structure of the country. But in the next rule, if you see, the first thing that they did when they came to power in 2019, they returned to power again in 2019. The first thing they did was to remove Article 370, or de-operationalize it, and suspend all civil rights in Jammu and Kashmir, dismember it, turn it into 2 union territories in the most illegal and illegitimate manner.
Anuradha,
And why? I'm
Anuradha.
winding up. This is just, yeah,
Okay.
I'm winding up. And why they did it? They did it because Kashmir is central to their project. It is central to the Hindu majoritarian narrative and Hindu majoritarian ambition of turning this country into a Hindu Rashtra. Jammu and Kashmir was the only Muslim majority state in India, and they cannot bear it. So we can only imagine, there were fears among the majority Muslims in Jammu and Kashmir, particularly in Kashmir, with respect to a demographic change. And these fears existed because from time to time, the RSS leaders and the BJP leaders have been talking about using the demographic change in, talking about bringing about a demographic change in Jammu and Kashmir as a solution to Kashmir issue. But these fears that seemed preposterous, they seem very real now. Thank you.
Thanks a lot, Anuradha, especially for joining us at an unearthly hour for where you are. I should have mentioned right at the beginning when I introduced her that recently in 2023, an excellent book has been brought out by Anuradha. It's called Dismantled State. And about Kashmir after the untold story of Kashmir after 370, Article 370. And those of you, I don't know whether you can, I mean, it's you may not be able to read it because of the mirror image, but it's an excellent book. And those of you who would like to know more about it should please order it. I don't say Amazon now, but order it from wherever you want to order it, Thanks a lot for all three of you. I think it's given us a very, very good picture of what is the history of Kashmir, the judgment, and what has happened after that. All 3 points have been covered. And one thing one realizes is way back in 2002, we used to say that Gujarat is a laboratory for all India. Possibly now Kashmir is the laboratory for the rest of India. And what is happening in Kashmir is something which is, I mean, the crushing of dissent, putting people in jail, controlling the media. All this is something which is happening now nationwide, of course, much more intensely in Kashmir, undoubtedly. Okay, so but we need to take care of that. Now, I would like to see if there are any questions, any comments, and if there are any questions or comments, if you can put it on the chat, it might be better. Is that how we go about it, Aishwarya or Kavita?
Yeah, because we had some hackers. So we had to throw them out, and then we've had to put everybody on mute. So we had to throw out some of them. Okay. Friends, please put your questions on chat.
If somebody wants to comment also, they can, comment.
Yeah, just a word here. Only co-hosts can see these, so you'll have to read it out. That's all.
Yeah. Okay. Well, in the during the time when the questions coming in, if there are any, Kavita, who is president of PUCL, is here. Does she? Would you like to say something, Kavita?
I was like very, very impressed by just the canvas covered and the questions raised. So I had just a few queries, from all the three speakers, that why is there so much silence? I mean, of course, Anuradha did try to dwell into that dimension of the kind of invisibilizing of the human rights abuse, and it's like every day and individual targeting. Yet, is it that there is no reporting about it, or is it that the people have just given up altogether on resistance? I mean, that is, of course, humanly impossible. Why does this silence that we hear? It just couldn't be media reporting. We could get to know it from elsewhere. Of course, this time I really missed the annual 6-monthly and annual report that JKCSS used to bring out on human rights violations, which is Now, I mean, their office has been sealed, they've been completely deactivated. So there we would get to know a lot about, the different kinds of responses, including, the state violations and what the militants are doing. We would get a pitch of the entire spectrum. That, of course, now we are unable to get it. Would like to understand, why the complete silencing? Even after this judgment, the parties spoke out, but the people were silent. Yeah, Mirza, I mean, this is very, very important for us. And just one more thing, the way the environmental policy is destroying all the forests of that area, because they're going to bring in various projects. Again, there is complete silencing. She did talk about the land, Anuradha. So I'd like you to dwell on some of this and let me.
Can I just add one or two questions which have already come on the chat? I'll just read them out. One is from Spandana. Wonderful session. I covered the case extensively, but there is always something new to think about. Would any of the speakers like to comment on the court's justification that 370 was not an indication of internal sovereignty, but of asymmetric federalism? That's question number one. The second one is from Madhuri, who says, would like to know more about how end of 370 has increased ecological violence and resource grab. There are two more questions. I'll read them out so that you can take them together. In terms of narrative building, judgments and their aftermath, we do see a certain inertia in the steady decline in democracy, human rights, and civil liberties. My question is, when civil society or citizens do reclaim back the space at a distant future, would they be dealing with a new normal from the specter of these landmark draconian laws and judgments? What's a way to analyze and go about this for even the hopeful? And the last two questions are, one is from Sen, Shukla Sen. When was the J&K Constituent Assembly dissolved? Post January 26, 1957? How a change in the Kashmir Constitution is to be made after the dissolution? That's a question. And the last question is from Shubh Mathur. What do you think will be the impact of changing geopolitical power structures? India has relied very heavily on the US and Israel for political and military support in repressing Kashmir. Now that the US is being replaced by Russia and China as the influential outside powers in the region, and Israel is facing strategic defeat, how will this impact Indian control in Kashmir, especially given China's strong stance on Ladakh? So these are the questions. They are not particularly directed at anyone, but all three of you can take them. Who would, Mirza, you would like to start?
Sure.
Yeah.
I can get started with the first few that I noted down. To begin with, the question on why there is such a deafening silence, right? Why the silence is so loud right now. I mean, part of it you referred to in the question as well, what is happening with JKCCS. Khurram is in jail, their offices have been raided. Even the interns in their office, anyone who's even worked with them in the past has been raided and questioned. So there is a severe clampdown on any kind of dissent, any kind of narrative that goes against the state narrative. And essentially, this is done to make observers, outsiders, whether Indians or foreigners, any observer becomes dependent on the state's version of reality itself. So there's no other narrative that is being permitted to come out. In fact, in the early days when Article 370 had been deoperationalized and the internet had been cut out in Kashmir, for any kind of journalism to take place, the little bit that was possible after the first month or so, the journalists had to go to a government-approved center and upload stories from there. So there was tremendous scrutiny. And I mean, there's a lot that we couldn't cover today. Another example I could give you of this is that after about 2 to 3 months of having no phone connection, no mobile or any kind of connectivity in the state, people were allowed to go to the local police station and make phone calls from there to their loved ones who were outside Kashmir. And even that was heavily monitored. You had to speak in front of the police over there. And most of the loved ones that you'd speak to, they just say, okay, we're alive, we're well, you take care of yourself. And that's essentially broadly what the conversation was about. So there is a tremendous fear that people are being monitored. And that fear is not unfounded or just in the minds of people. Right now in Kashmir, 20-year-old, 30-year-old cases are being dug out against people to bar them from employment, if there is any history of someone being involved with what they call anti-India activity, they are being prohibited. Their employment is being terminated, and there have been cases where people's passports have been they've been barred from foreign travel. Their passports have been affected. People who have overseas citizenship of India also, who are citizens of other countries, like in the UK, their OCI has been revoked as well. So there is a clear message that has been sent out that if you speak out against the government, then they might come after you. So that is definitely one big contributing factor to why there is so much of silence right now. It's difficult to speak, and even the little that we have spoken today doesn't fully cover the depravity of what's taking place. A little bit of what Anuradha had also touched upon was about the militancy. Like recently, you must have seen the ghastly videos of torture that came out against the workers, the people in Kashmir over there, which was just viral on social media as well. So these kind of things have been used as a sounding board for people that they will come after you. And in fact, the treatment that was meted out to elected chief ministers also, Umar Abdullah, Farooq Abdullah, Mehbooba Mufti, it also was a sounding board that if this is the way they're treating people who have stood by the Indian state for so long, then how will they treat people who are not standing by the Indian state or are critical of the Indian state? So that's why I feel that there is a tremendous repression right now, and the UAPA has been abused for absolutely frivolous cases in Kashmir in the past. Some people playing a cricket match had UAPA imposed on them. Used for use of internet, UAPA for social media use, UAPA had been invoked as well. So there is a tremendous, sweep of broad power that the state machinery has, and it can be deployed against people. So that definitely is a huge factor in the silence. I think there was one more question on resource grabbing. But yes, the resource grabbing it has exacerbated quite a lot, because one, the the preference has been given to non-Kashmiris for most of the tenders and contracts. For example, the tourist areas in Kashmir, where a lot of the hotels were on lease from governments, they were up for renewal, and the people who would be bidding would be from outside Kashmir. And because there would be a lot more money to bid from outside, the chances of them getting these tenders are higher. And a lot of these protections were in place in Kashmir to protect the local businesses, local industry. And one example that we had seen of this was when the sand mining contracts came up for tender, about 90% of the ones that came up were won by people from outside Kashmir. So there is a resource gap. There's gypsum mining also that takes place in places in North Kashmir, which is also right now being heavily controlled by non-Kashmiris. So most of the industry, if you look at even the J&K Bank, how they had been hounded out, and how the control that J&K Bank had within Kashmir to provide loans, to provide some small local semblance of economic freedom over there, that has also been curtailed. And on the question of geopolitics, I can just comment very briefly on that before passing it on to the other speakers. That yes, of course, there's going to be a huge impact, because this opens up space for China to play a new role over here. And Pakistan had recently come out with new maps where they do not claim the region of Ladakh that is claimed by China. So Pakistan had omitted that region from its maps, the official map that they have. So there is definitely a new role that China is interested in playing over here, and they have been very hawkish on these developments. However, the Indian state has been very cautious in dealing or commenting on China because of the stature and the difference in military might that there is, in my opinion. And they're not so cautious when they talk about Pakistan. So with Pakistan, they're always eager to comment on going to war, whereas with China, even when soldiers died at the LAC, there were orders that no weapons should be used. And we saw one ghastly incident where there were hockey sticks and baseball bats with barbed wire, because of which some soldiers on both sides suffered injuries. But the situation is quite tense over there as well. And a large portion of Ladakh territory, and this had been spoken about for some time in the media when this was happening, but after that there was complete silence over this. A large portion of territory in Ladakh has already been taken over under Chinese control right now. But there's very little conversation about what has happened to that territory, how much of territory has been taken. There were reports initially that all the way until Daulat Beg Oldi, which is well, several hundreds of kilometers into what is Indian, what India claims is within its jurisdiction. That the Chinese had moved until there. But there isn't much that is now being spoken about it. In fact, the official statement is that there is no territory under Chinese control. So, but that remains to be seen. So definitely there is an escalation taking place of these tensions. But I don't see any immediate any outbreak of war happening immediately, because Pakistan does not seem to be in that position right now to take on a military activity. But you never know with these things. Means we've seen in the past also how these things have escalated, and how it can change. So there's definitely tension over there, but it remains to be seen how it will impact. If the other speakers would want to add anything, please go ahead.
Yeah.
So
Yeah,
Sanjay ji, I
Yeah,
think
I'll
please go ahead with some
I'll
specific
speak about
questions to
there's one
you.
question with regard to the asymmetric federalism and internal sovereignty. Let me explain that as far as the asymmetrical federalism is concerned, Dr. Dhawan had argued by pointing out different provisions in the Constitution that the principles are not same as far as different states are concerned. There are specific features, and therefore, when we talk about federalism, it's not symmetric in nature, it is asymmetric depending upon so many factors. Sovereignty was a totally different argument. And Justice Sanjay Kishan Kaul has not agreed with this particular finding which has been given by the majority, because he says, if you look at the history, and which I tried to explain briefly, is that once you recognize the presence of Constituent Assembly and a will of the people ultimately, then that shows that the internal sovereignty existed. And that's what the judgment in Premnath Kaul's case pointed out. So these are two different principles, and they have been mixed up by the majority judgment given by Justice Chandrachud. But then the other judge has pointed out, and I think rightly, that these two principles are different. A second thing which I just wanted to, I forgot, I must mention it, that principle of that statehood and dividing union territory, that has not been decided because of the statement given by the Solicitor General. The other important question has also not been decided. That is to say, the proclamation which was issued by the governor and subsequently by the president, on the ground that there is no challenge to it. So virtually, the judgment has not decided any of the important constitutional points in this particular decision, the majority one as such. Yeah.
Anuradha, would you want to?
Yeah, I can't really go into the legal aspects. I leave that to you. But looking at the asymmetric federalism argument, I mean, and politically so, that it's been kind of presented in a way that, it's a kind of handicap. There's nothing evil about an asymmetric federalism. In fact, it's a very good model, which has been practiced by many countries that have given autonomies to various regions to resolve the issue. And as far as Article 370 is concerned, it was based on this very principle of providing a different system within the country to the people of Jammu and Kashmir. It was an affirmation of the different the autonomy of the people of Jammu and Kashmir. It was an affirmation because it was rooted in the instrument of accession, which was different from the other instruments of accession. That it was a recognition of the dispute of Jammu and Kashmir, the pending dispute. And as far as geopolitics is concerned, I think Kashmir and geopolitics have always have gone hand in hand. It's geopolitics that has in some way or the other geopolitical interests shaped what has happened internally within Jammu and Kashmir, whether it was, right from the days of Sheikh Abdullah's arrest and when militancy started in 90s. And everything has had, so there would be, but geopolitical interests don't remain the same. We've seen the ups and downs. We saw militancy come, we saw the peace process start. So it depends, and there's a lot of push that comes from geopolitical interests. So when the tectonic plates shift, things may look different within the region. I think that, yeah, the other thing about the Truth and Reconciliation Commission, I think that's a very Justice Call's verdict was kind of the strangest of all, though he says that he does not he thinks differently, and yet he says he concurs. And then he adds, so there are things added like Truth and Reconciliation Commission. Now, Truth and Reconciliation Commissions are usually, we look at the South Africa model. That happens when the conflict resolution has happened. And after that, or, at least it should begin when the conflict resolution stage has started, we can still talk about Truth and Reconciliation Commission. So what is this Truth and Reconciliation really about when you have tyrannized people, surveilled people, completely controlled people? So whose truth is going to be told here? Who is going to reconcile to what? It doesn't make any sense.
Yeah, very rightly put, Anuradha. But it doesn't make sense as to what will be presented as truth. But by itself, I felt that the Truth and Reconciliation Commission could only take place if we have a shared understanding of the facts itself. I mean, there's narrative about what has happened in the 1990s, what happened to the Sikhs, what happened to the Kashmiri Pandits and the Kashmiri Muslims also. But there's not even an investigation that has taken place, not even a ascertaining of facts of the massacres that have taken place in the 1990s. So that Truth and Reconciliation process, while it would be highly useful for a fractured society to move on eventually, but we're quite far from that stage as of now, given where we are in the situation.
There's a question for Sanjay. Anjumara, if 370 can be abrogated, does it mean that Article 371A and other provisions of Northeast India can be abrogated too?
Yeah, this question was raised, and ultimately I think there was a petition also filed, and then there was a statement recorded that this is only concerned about 370. As far as other articles are concerned, they will not be touched upon. So there is no question of going into, because 370 has a different kind of features.
Thanks, Suresh. Suresh, General Secretary of PUCL, would you like to say something before we wind up the session?
Yeah, I think just responding to your issue, Sanjay, about Article 371A will not be taken up, etc. Now, how much credibility can be placed on it is a question, because if you see in the Ram Janmabhoomi, the Ayodhya issue, on the whole law relating to religious places of worship, they said that this will be the last issue that they'll take up, but the same CJI now has taken a contrary stand to what he wrote as part of the 5-judge bench with regard to the other two issues that are coming up now in UP, the Gyanvapi case and the other case. So to what extent will this assurance that was, or the statement that was made in the Supreme Court that the Article 370 case involves only Kashmir and it will not have other cases, is a question I also wanted to pose to you and ask you in terms of how do you see that. That apart, I think there's one issue that is worrying me, which is that of the demographic displacement that's taking place and a demographic geography, a new demographic geography being engineered in Kashmir. Now, in the light of all the issues that Anuradha and Mirza have been talking about in terms of what's going on there, much of which mainland India does not really know much about, in terms of constitutional protections, what can the human rights movement be doing about it? And this is a question to Mirza and to Anuradha. What should the larger human rights movement in India focus on in terms of a constitutional character in terms of our campaigning to protect the rights of the Kashmiri people or protect the rights of people in Kashmir, in Jammu and Kashmir? So what should we be doing? In what manner can we expand the protections of constitutional rights is a question, especially in the context of demographic displacement that taking place. And to Sanjay, as to what will happen if Article 371A is also touched upon later, because politics in the Northeast is also changing and changing quite fast, especially with the election of Mizoram, of a new government in Mizoram, and them telling Amit Shah yesterday that please don't put up the fences on the border with Myanmar because of this type of human rights violations that are taking place in Myanmar. So is it like, I mean, if the issue is taken up, how do we legally understand that context? These two broad questions.
There was a petition which was filed, and it is the advocate and I think member of parliament from Congress. He had put this petition that you have challenged 370, and tomorrow 371 and other articles will also be challenged. There is an order which has been passed by the court. And again, I think in that order, I'll have to see the statement of Solicitor General has been recorded that they are not going to touch upon those provisions at all. Now, you may be right. This is what is happening. And on the basis of statement, so many things are decided when they are constitutional questions. So I'll have to look at that particular order, what the Supreme Court has said. But you may be right that tomorrow, suppose challenge is put, then how it has to be responded, because that particular order may not come as a shield or as a defense that no, you cannot challenge it. It can always be on certain grounds challenge. So now that's a very, very important question, that how we'll be looking at that. Certainly, so many important questions will arise. And that has to be seen, I think, from it's an important question and to be discussed in depth and detail, I suppose.
On the question of domicile law and demographic change, I didn't get much time to go into that in the discussion earlier, but essentially, the first thing is what can Indians, non-Kashmiris, do in this situation to support and prevent demographic change from taking place? I think there's a lot of protection that someone who's not from Kashmir inherently has by not being from Kashmir. There's a lot more freedom to speak up, to talk, to mobilize, to organize that people from Kashmir don't have right now. So definitely those spaces and those opportunities those safe spaces can be created by non-Kashmiris. And we need a very mobilized action which is directed at presenting how this is an illegal action. Because see, if Kashmir was not a disputed territory, then anyone moving anywhere within the same country would be fine. But it completely upends any future resolution by way of a plebiscite or by self-determination, which is what essentially demographic change will do. Because you have to think of this 10, 20, 30 years down the line. If there is demographic change in Kashmir and if non-Kashmiris move there, then 20, 30 years down the line, when those people have their children born into Kashmir, it becomes very hard then to talk about resolution of who votes on self-determination, who votes whether Kashmir has to become independent, part of Pakistan or part of India. So essentially the whole question of self-determination then gets thrown out of the window there. So the United Nations resolutions, all those things. But it also complicates things in a very dangerous manner, because if within Kashmir the volatility increases and if there's a resurgence of armed rebellion, what will happen then in that situation to the new settlers? And we already have parallels around the world where settlers have been placed in a situation where there's demographic change taking place and locals are being pushed out. And then those locals will resort to whatever means possible to protect themselves, their livelihood, their resources, their properties. But with respect to the domicile law right now, the demographic change is taking place, but not as rapidly as we had initially anticipated. And this is not because of a lack of efforts from the government. This is essentially because no sensible person wants to move into a war zone with their family and children. And Kashmir is a highly, highly volatile place. You have to be particularly desperate or heavily privileged to be able to move there. But as of now, there are people who may try to buy holiday homes over there, or maybe investments in terms of creating a film city or things like that. But by the law that has been, the rules that have been passed, as of now, a new class of citizens has been created for Kashmiri domiciles, where any Indian citizen who has resided in Jammu and Kashmir for a period of 15 years, or has studied in Jammu and Kashmir for a period of 7 years, or has parents who have served in Jammu and Kashmir for a period of 10 years, they're eligible for becoming domiciles. And just to create an urgent, I mean, the sense of urgency in the state was apparent, because the state had attracted a penalty of 50,000 rupees if someone who has applied for a domicile certificate wasn't immediately within 15 days who was not given one. So we don't see a very large number that has come in, but there are a lot of people who are eligible. In fact, Kashmir has a lot of migrant labor coming in from central India, because the daily wages that they get in Kashmir are much higher than even Gujarat and Maharashtra. So many of those people, in fact, the number is well above 1 million people already who are eligible. And then when you count the number of central government employees, the armed forces, and other people who are stationed over there, the numbers are quite high, and they're high enough to swing some constituencies, which is essentially connecting then again to the delimitation and how the BJP will then engineer a result of elections in their favor in Kashmir. So these things need to be brought about more vociferously, more clearly, about what is the fraud actually that's being played over here, and why it has to be rejected outrightly by everyone. So I think that's the role that non-Kashmiris can play with the whatever little safety is added by not being in the jurisdiction of Kashmir.
Thanks, Mirza. I think we have gone beyond the time which we had set out ourselves for this meeting, but then the issue is such that some amount of stretching was required. It was an excellent. I thank all the speakers for having participated and been there throughout the meetings, responding to questions, responding to comments. I thank, of course, the entire body of PUCL, as well as all the other participants who have been who have come here and actively participated in the meeting today. PUCL dialogues are something which we have started some time back, and it's not and the frequency has become higher over a period of time. And as soon as an issue which is something which we feel requires a national discussion on, we normally have this PUCL dialogues. We'll keep all of you intimated about the future dialogues which happen. The only thing I can say on behalf of PUCL is that we will try our best. We have had fact findings earlier in Jammu and Kashmir, had various other interventions in Kashmir, etc. We were one of the petitioners in the Supreme Court case against 370. And we will try to continue to help in whichever way we can the people from Jammu and Kashmir. And on that note, I think we can end this